Hey, everybody, welcome to another podcast here or video or whatever you want to call it. Maybe one of these days I will create an actual sort of intro or whatever. But hey, all right, what's going on? John, good to see you guys. Cigar Cigamo, living in America. Everybody, hello. So got a great video for you today, and it's a case out of the Northern District of Texas for the Fort Worth Division. This is a federal case, and it was written by Mark Pittman. And it's, keep in mind, hopefully that this has got very solid footing. One of the greatest things, one of the biggest things that I always got onto Trump about was that he did absolutely nothing for the Second Amendment. Nothing. As a matter of fact, he did more to restrict our Second Amendment rights than Obama did, because remember, it was under Trump that they created the bump stock ban. So, and he didn't do anything to stop that. As a matter of fact, he pushed for it. So anyway, but the good thing that he did, of course, was get people into the Supreme Court who were originalists, who understood what the purpose of the Second Amendment and other aspects of the Constitution were, so that things like this that happen right now would happen. And I think what we're going to start seeing in the next few years, is a lot of these gun laws are going to get tossed. Now, let me just tell you what's going on right now. As you know, in Texas, you have the right to keep and bear arms unless you're 18 to 20. If you're under 21 and over 18, you have no right to bear arms except for carrying a rifle everywhere you want to go. Yes, you can carry a firearm in your vehicle because you don't need a license there. But if you're going to carry it on your person in public, you've got to have a license, or you've got to be 21 years old. So what happened was the Firearms Policy Coalition, along with two defendants, sued because they were 18 to 20 years old and their rights were being violated, saying that Texas's law that requires you to be 21 years of age to carry a handgun is unconstitutional. So we are going to talk about that case right now. And here's the case. It is, let me put this down here like that. There we go. This is the number for it, 421 CB 1245P. And we're going to go over this not entire case, because a lot of it really kind of repeats itself. But I'm very happy at this point in time, right now, as we sit here right now, if you are an 18 to 20-year-old, the law that applies to not being able to carry a firearm, as long as you're a law-abiding citizen and you can legally own and carry a firearm, does not apply. The state law it has been ruled unconstitutional. So we're going to go through this here. I highlighted the stuff that's really important. This is really the biggest issue here: whether prohibiting law-abiding 18 to 20-year-olds from carrying a handgun in public for self-defense is consistent with the nation's historic tradition of firearm regulation. Keep in mind, this is a Bruin. Okay, this language here, the historical tradition of firearm regulation, it comes straight from the Bruin case, because prior to that, they used a test to find out whether something violated the Second Amendment. And then they go on, based on the Second Amendment's text, as informed by the founding era history and tradition. This is another statement that comes out of Heller, as well as the Bruin case. The court concludes that the Second Amendment protects against this prohibition. The Second Amendment protects against banning or prohibiting law-abiding 18 to 20-year-olds. Texas's statutory scheme, therefore, must be enjoined to the extent that law-abiding 18 to 20-year-olds are prohibited from applying for a license to carry a handgun. So keep in mind, this is still somewhat narrow, okay, because the petitioners in this case wanted a license to carry a handgun. So they're not arguing, and the court is not deciding on the right to keep and bear a handgun without a license, okay, without a license. So this decision, while it's a good decision, only applies to whether you can carry with a license. In other words, as of right this second, if you are 18 to 20 years old, tomorrow, you can go, well, probably got to wait till Monday, but tomorrow you can go and apply for a license to carry a handgun in Texas because you have a right. That's what this court is saying. What it's not saying, because it's a narrow case, is that you can carry without a license if you're 18 to 20. Okay. That's going to have to be a whole separate case that the court is going to have to decide, because this was a very narrow issue as brought up through the court system. Okay. Now, in Brune, the Supreme Court reiterated the standard for applying the Second Amendment. And this is where they rejected that two-step framework that had been adopted previously. And they said that that framework is inconsistent with Heller's historical approach and its rejection of the means in scrutiny. That came from the Brune case, but it was quoting, of course, Heller. And then I love this right here. Courts must first interpret the Second Amendment's text as informed by history, And they go through a great sort of analysis of that. So they broke it down into several smaller issues on the merits. The first one is whether Texas can prohibit law-abiding 18 to 20-year-olds from carrying a handgun for self-defense outside the home. It goes through a lot of the Second Amendment text. And this right here, it's undisputed. You know, the Democrats like to say that, things are undisputed. Well, the court is right here saying it is undisputed that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. Again, that comes from the Brune case. Brune is going to help us get rid of a lot of these unconstitutional laws that are out there right now. So then the case becomes, well, are law-abiding 18 to 20-year-olds a part of, quote, the people that's mentioned in the Second Amendment? And of course, the court says, as explained below, it says right here, the court concludes, yes, 18 to 20-year-olds are part of the people. Now, we already knew that. We already knew that the militia has always been able-bodied adults, between the ages of whatever to whatever. And of course, that encompassed 18 to 20-year-olds. You look at the Revolutionary War, you look at the Civil War, how many 18 to 20-year-olds fought in those wars and others, Mexican-American War and things like that. The World War I, World War II, okay? The militias, all the militias. So the Second Amendment does not mention any sort of age restriction, because when the framers meant to impose age restrictions, they did so expressly. Like you look at, when they said that who's going to run for House and who's going to run for Senate, they said you got to be 25, you got to be 35. Right? They put age limits on those things. When they did the right to vote, when they recognized where states cannot restrict the right to vote, they put age restrictions in there. I mean, granted, those are more recent, but the fact of the matter is that an age restriction, whenever the framers meant to impose one, they did. And what's great about this is he goes into a lot of incidents here, and I'm not going to necessarily read all of this stuff, but there's case law that the Fourth Amendment, okay, well, if you're 18 to 20, you've got a Fourth Amendment right, not, to be free of illegal searches and seizures. The court said in this Verdugo case that it's all of those persons who are part of the national community or those who have significant connection to this country to be considered a part of the community. Ordinary law-abiding citizens are part of the people whom the Second Amendment protects. Again, there's that Bruin. So you got the Fourth Amendment there. The court talked about other cases. If you go down here, the First and 14th Amendment refers to the people, right? And does the First and Fourth Amendment apply to 18 to 20-year-olds? Absolutely. And what's great about these recent cases, and what we always realized, is that the Second Amendment is not a third rate. This is what they argued in Heller, that the Second Amendment has become essentially a third rate right. It's one of those rights that for some reason it's been okay to infringe upon, whereas the First and Fourth and Fifth and Eighth and all those others have not. They've always been very well protected, but the Second, for some reason, they've been able to put all of these restrictions on, even though the language is almost identical in many ways. So the First and Fourth Amendments, like the Second, refer to the people. The First Amendment has been interpreted to apply to all persons, even those under the age of 18. And while the First Amendment is limited in some contexts, for example, forum or content, age doesn't serve as a basis for eradicating that right. So why would it eradicate the Second Amendment right? The Fourth Amendment, likewise, protects individuals regardless of age. The Eighth, later on, it talks about the Eighth Amendment. Thus, because neither the Fourth nor the First Amendments exclude, nor have they been interpreted to exclude 18 to 20-year-olds, well, this court that's writing this opinion declined also to see that there's an implicit age restriction in the Second Amendment. And then they talk about other rights that have been specifically mentioned. The people supports this opinion in this case that the people protected by the Second Amendment include 18 to 20-year-olds. Likewise, the Eighth Amendment, the Supreme Court has said where a line must be drawn, quote, the age of 18 is the point where society draws the line for many purposes between childhood and adulthood. So we're either going to have to redefine that line and make that line 21, and thus it's going to affect everything else, or we have to recognize that 18 is the age of adulthood, and therefore the Second Amendment and all other rights apply equally if you're 18 years old. The court continues the line and just, again, it says, look, it's just rational. This just makes sense. If you have a right to do X and it says the people, then you have a right to do Y when it says the people. The Second Amendment contains two clauses. Logic demands that there be a link between the stated purpose and the command. So they go into a little bit about the militia and talk about, the preparatory clause, and the fact that, since the Second Amendment stated purpose, logic demands that if an individual was or is a member of the militia, the Second Amendment protection extends to at least those who constitute the militia. It must protect at least the pool of individuals from whom the militia will be drawn. And it would be illogical to enumerate a constitutional right to keep and bear arms to maintain an armed militia if that right did not protect those individuals from whom the militia would be drawn. And if you look at the United States v. Miller case, the Supreme Court made clear that the militia is comprised of all males physically capable of acting in concert for the common defense. And in many cases, the militia was generally understood to be comprised of all able-bodied men, which included 18 to 20-year-olds, and in fact, in some cases, as low as 16. So the first Congress even enacted legislation, the court continues, commanding that every able-bodied male citizen between the ages of 18 and 45 be enrolled in the militia. If you don't have a right to keep and bear arms, so the individual right to keep and bear arms, which is the operative clause of the Second Amendment, you have that individual right to keep and bear arms so that you can engage in service in the militia. Why would you not have a right to the weaponry to be able to do so? And it's not just rifles that are in the militia. It's pistols, it's bayonets, all kinds of things. So, history and tradition, which is what the Bruin standard is, has always included ages 18 and up. So because they were included in part of the militia, the Second Amendment must obviously protect the right to keep and bear arms. You and I know this. We've known this. We've been arguing this forever. But for some reason, there are those out there that just want to try and restrict. This isn't about whether someone is 18 to 20, because that's the first sword to fall on. Then it's going to be 21 to 25. And then it's going to be, they just want everyone to be disarmed. So don't be distracted by whether or not this is an argument over whether it's, justified that 18 to 20-year-olds. Look, my daughter is within that range. She has a right to defend herself. She's off to college right now. As a matter of fact, I'm filming from her room. I feel better knowing that she could protect herself. She's an adult. She's out of this house, living on her own, working on her own, earning a living, going to college, and has the right to protect herself. So the court does conclude that the plain text of the Second Amendment does cover the proposed course of conduct and permits law-abiding 18 to 20-year-olds to carry a handgun for self-defense outside the home. And it's something that you and I already knew. We always knew. And that's essentially what all this goes. Now, I went through the rest of this, but that's essentially what it is. They go into more of the history and all that kind of thing. But the bottom line is I highlighted for you the areas where they made their decision. We can go down here to conclusion and show you what this court is ruling. So the court's giving them a 30-day stay on the injunction. Okay, so they've got 30 days to appeal this. So it's going through the system, and if they prevail on the merits, this is going to go higher. Look, this is going to end up again in the Fifth Circuit at the very least. It's going to end up probably at the Supreme Court level. I don't see them winning. I really don't, because when you use the Bruin standard is that it's history and tradition. And historically and traditionally, 18 to 20-year-olds have had the right to keep and bear arms. Now, what I will say here is there might be a way for them to claim, because as you know, I graduated when I graduated high school, just because of when my birthday is, I was 18 years old. So I was still in high school for a few months before I graduated. And I think the court would likely find a ban on 18-year-olds who have not graduated from high school as probably constitutional, because I don't know. I don't know how they'd argue that. Maybe just at schools. I would say, just because I'm still in school, if I'm 18 years old and I'm not in school physically, that I should have that right outside of the school. It would still be against the law to carry that firearm in there. So the motion to dismiss was denied. The motion for summary judgment was granted for the plaintiffs. In other words, that they have the right to keep and bear arms at the age of 18. But here's what they're doing. Defendants and their officers, agents, employees, blah, 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 are hereby enjoined and restrained from enforcing Texas's statutory scheme against law-abiding 18 to 20-year-olds based solely on their age. But, okay, so remember I said that, at this point, you can go and request a license. So that's the law. That's the law. You can do that. But there is a temporary stay on that order for 30 days, okay, or pending appeal. So and then it will be to stay if they file an appeal within 30 days, then they can continue to enforce that restriction while the appeal is going through. All right. So I want to clarify the law is a weird thing. This judge has ruled that as of today, you have the right, 18 to 20-year-olds, to request a license to carry, to apply for a license to carry a firearm, openly or concealed, outside of the home, in public. However, even though that's the order and that no one in government can not keep you from doing that, the court has said, I'm going to give you 30 days to figure this out, right? Or to appeal. So in other words, in 30 days, this order goes into effect as if nothing's going to happen, okay? Because obviously they've got to figure out how are we going to deal with these 18 and 20-year-olds. So he gave them essentially 30 days to get in line or 30 days to appeal. I'll tell you, if they appeal, the Fifth Circuit's likely going to uphold it. And if the Supreme Court gets it on appeal as well, they're likely going to uphold it, because the Bruin case is very solid and protected. It's very natural in what it says, I think. So that's what it means. So in other words, when I made the joke about going Monday to sign up for a license to carry, don't do that. I was being facetious. You're supposed to be able to do that, but the judge has put a stay on that order to give the state enough time to adjust to it and or to appeal the case. Now, if they appeal, that stay is going to continue until the appellate process is over with. And I just wanted to bring this case to you because this is very good stuff. This is very good case law. I think we're going to see a lot more of these cases, especially what they're doing up in New York, where they're trying to make all of these things so-called sensitive areas so that they can ban guns in all these sensitive areas. I think you're going to see it in New York, probably going to see it in places like South Carolina, where open carry is banned, Florida, all those kinds of things, because the history and tradition of guns, especially at the time of founding, more was conducive to open carry than it was concealed carry. So historically and traditionally, open carry was always the preferred method of carrying. So you have in states like New York, California, Illinois, South Carolina, and Florida, which are the only states that ban open carry, you probably have a right to open carry now. You just got to, because that's what the history and tradition is. You can challenge that law based on the Bruin case. All right, who would be appealing this? The state of Texas would be appealing this because that's the Texas DPS is essentially, as a matter of fact, let me go back to this. I'll show you who the parties are. The party is actually Stephen McCraw, who's the director of DPS. So that's who would be appealing the case, is DPS. And I can tell you, Director McCraw is a communist. I don't like him. I don't understand why Greg Abbott keeps him on, but he does. The guy doesn't like guns in any way, shape, or form. He's done everything he can to undermine the Second Amendment, by not only supporting the ban on rifles. We've taken rifles to the Capitol for decades prior to 2014. And then all of a sudden the open carry movement starts and, they decide, oh, you know what? We're not going to have rifles on the Capitol grounds anymore. Even though we've been taking them there forever. As a matter of fact, before my arrest in February, a month before my arrest, I was at a giant 223 rally at the Capitol with my rifle. So that's who would appeal it. Texas DPS would appeal it. All right, let's see. What else we got? 30-day stay. Okay, I talked about the 30-day stay. I think that's all the questions, folks. My 17 to 20-year-olds are all in the Air Force at that age. One still is that age, but can't buy a firearm. Yep, exactly. All right. Well, y'all take care. That's it. Y'all be safe and be free. And I will be back here the next time there's some good cases to discuss. Later.